Hi there, it's Carl Irwin, and this is going to be hopefully a relatively short video. I'm not known for making short videos. I have a couple of YouTube channels. This is one of them. I have one where I do close-up magic. It's a hobby of mine. My profession really is in music. I'm a music educator. I'm a teacher, a public school teacher in New York State, but I'm also a composer, and I write music for projects as they arise, but I make my living in teaching. Um, this is going to be a short video, hopefully, on Musescore 4, Muse Sounds, GPL licensing, and copyright. So I've already done a video on copyright on another channel that I have, iScores Music, where I was focusing mostly on Linux production. I've made this other channel just by my name, Carl Irwin Music, where I can put my compositions specifically and put more general kinds of discussions and tutorials about music creation, composition, and music creation, not really focusing on Linux specific tools, but more general concepts that it doesn't matter what platform you're on, you can learn something from it. So that's what this channel is for, and I'm probably going to grow this channel and let the other one kind of terminate. So I've already addressed this copyright issue on that channel. Unfa, if you know Unfa, is a Linux digital musician. He's probably on a number of message boards where this will be posted as well, and forums. And a while ago, he created a video demonizing, essentially, virtual playing orchestra, Paul Battersby's VPO. And his point was that there's shady copyright business going on with the CC licensing. And he had particular complaints that he was making about it, about transfer of licensing and how some of the sources were not clear and that sort of thing. And I responded to that late, well after he created his commentary, and I talked about copyright law, and it's going to be a little bit of that discussion here. And I explained there's nothing wrong with VPO. In fact, there's probably more wrong legally in saying that there's something wrong with VPO than there is possibly wrong with VPO, because there's certainly the potential for defamation there that you want to be careful about, defaming someone's work. But one of the issues that I dealt with on there was the transformative quality of instrument libraries, that they really satisfy copyright law with respect to what they are versus what they are used for, provided to be used for, and that where they are provided, the thing they are provided as, and the thing they are used for are not connected as derivatives. One is not a derivative work of the other. It is a use. It is a purpose. It is a satisfaction of the thing, of the tool. And I made this argument, of course, using hardware that you probably have. If you have a synthesizer, like a Korg synthesizer or a Yamaha that's got samples on it, obviously you don't own those samples. You don't own them. The company owns the samples. You own the machine, you bought the hardware, and certainly you can play it and you can use that on any kind of musical work that you want. But the thing you can't do is you can't extract those samples and then distribute those samples as samples in a library, because that violates the copyright of the tool, of the library set, of the actual recording. That's a violation of the sound recording as covered in copyright. Whereas use as the tool for the purpose of the tool is not. And it's not a loophole. It's not. It's clearly written into the language of copyright, right, and the doctrines that go in there. So let me dig into this a little bit here deeper and try to be clear. There is only one law that we're dealing with, and I think people who are really into open source work and FOSS and various kinds of licensing, they think about these licenses as being legal. The licenses are a form of legality, but they are not law. I think it's important to understand that like Creative Commons, right, the people that make the Creative Commons licensing, they don't generate law. That license is not law. The license follows under contractual law, right? It is a contract of form, and it functions as an interpretation, or rather a relinquishing of the law, which is copyright. Copyright is the law, and it is the only law. So when we're dealing with law here, we're dealing with copyright, period. There's not something else. The GPL licensing is not the law. It is a license that deals with the law, which is copyright. Now, there's cute terminology that goes along with some very serious philosophies. I don't want to demean it in any way, but you have copy left and all this stuff. There's only one law that is copyright. Copyright is the law, and it's a very important law. If you write music, you musicians out there, if you write a piece of music, it belongs to you. You can relinquish your rights using some of these licenses and give that up. Certain aspects of it, you can't retain really any other rights provided by copyright that are outside of copyright. You can only retain the rights that are provided by copyright. You can relinquish some of those rights. If you do relinquish those rights, you certainly can't take them back once you've published it. That's what these licenses deal with, is they spell out the parameters by which a person gives something up. It does not define the parameters by which a person has rights. Those rights are provided by copyright law. Whatever is in the license that spells those rights out, it is merely just pointing back to the law. It is not creating anything new. They cannot create any new restrictions. Okay, so it's very important to understand that at the onset. Okay, so now what we're dealing with here is Muse Sounds. Now, Muse Sounds has a license. We're going to talk about how Muse Sounds interfaces with the program and some of the interpretations of some of the subsystem files that are part of the program, and how some have concerns about that violating the GPL licensing for Musescore, which is an open source project, right? Whereas Muse Sounds is not. So here is the end user license agreement, which anybody who's been dealing with this seriously has probably looked at already. Okay, but and I'll read just a little bit of it, the relevant part. If you go to number 4 in the end user license agreement. Actually, before that, go to number 3, Muse Sounds service. Muse Sounds is an online service. So it defines what Muse Sounds is. Muse Sounds is an online service that allows you to browse and download pre-recorded sounds, sound effects, loops, and samples. So in the definition of what Muse Sounds is, it is a service. It is an online service, okay? Musescore is not an online service. Musescore is a notation application with a playback engine that is part of it as well. But Muse Sounds is not that. Muse Sounds is an online service. It is an online library that is provided to you for download, right? To finish this out, that allows you to browse and download pre-recorded sound effects, loops, and samples, sound files, and software files in quotes. Together, the sound files and software files and all accompanying downloadable documentation are the products. That is what Muse Sounds is. It is a library. Muse Sounds is a library. That is the beginning and the end of what Muse Sounds is. And that is where the proprietary license exists. Anything outside of that does not have that license. So when you're looking at any aspects of the code pertaining to Musescore itself, all of that is part of the open source GPL licensing. And all of that is available for anyone to create any other library to interface with it. So that is why this is completely fine. It is completely fine. There's really nothing questionable about it. To explain this a little bit further, point number 4 might seem strange if you've never read licenses for sound libraries before, instrument libraries, virtual instrument libraries. This may sound suspicious, but this is actually par for the course for almost all virtual instrument libraries that you can buy, whether it's East-West, Spitfire, Cinesounds, all these other companies that make a variety of different libraries, some free even. all have the same licensing, and this is a free library. Number 4, license for download and use of products. By purchasing, so this is the license right here, right, for the download and the use. This is point item number 4 in the end user license agreement is what you're really focusing on. By purchasing a product, which product is defined in the previous, the sounds that you download, and subject, and purchasing is curious because you don't. Purchase literally means the download because it is a free thing. They could charge for this. They might charge for it at some point. I hope they don't, but they might, and they could. By purchasing a product and subject to your compliance with this agreement, which usually is implied by usage, is typically how that is understood. Muse Sounds grants you, and you only, a non-exclusive, not just to you, non-exclusive, non-sublicensable, means you can't license it, non-sublicensable, non-transferable, can't transfer it, license to download and use the products you download from Muse Sounds, provided always that you use the download sound files only within your own newly created sound recordings and or performances in a manner that renders the sound files substantially dissimilar to the original sound of the sound file in each case. Okay, so this language or something like it is in almost all virtual instrument libraries. Now, the interesting thing about this is that they don't actually have to put that in there because the copyright law already addresses that. That very concept is already written into the law. In U.S. copyright code, we have something called fair use doctrine. Now, I know that there is not language for this in all copyright universally or globally, but nonetheless, the concept of fair use is not a loophole. There's a lot of people that treat fair use as some kind of loophole. They'll say, I'm using this under fair use, right? Fair use is really the law. That's the point. It's that someone who has a copyright can't overly restrict someone from something that they shouldn't be restricted from, right? I can't create restrictions on somebody outside of my claim to ownership. I can't create additional restrictions, right? Fair use comes into play when the thing itself is used in such a way that does not violate the ownership of the thing, right? Could be something visual, it could be anything. Copyright, let's just be clear on this. Copyright, by definition, is the right to copy something. So in order to copy something, it has to exist in a tangible medium. It has to be an audio recording. It has to be a physical manifestation of something. It has to be written down. A picture has to be taken. There has to be some kind of physical record that exists of the thing, because otherwise, without a record, it can't be copied, right? A piece of music only exists in copyright in tangible form. The fact that I've composed a piece of music, it's not the intellectual concept of the music that is copyright. It is the actual thing itself, the medium, either the audio recording or the notation itself, right? And it's not merely the representation of it, it's the thing. Now, this gets really interesting, particularly with music, because when we're talking about copyright, the thing I'm recording is manifest differently, can be manifest differently on different tones or different instruments, we'll say, right? I have a copyright claim on a song that I write that has a melody. And what I'm saying is I don't necessarily own the intellectual property of the melody. I own the melody in a form that can be copied. But there's a paradox there, right? Because if that melody, even though I have it recorded, maybe in notation, is played somewhere else and recorded as an audio recording, that copyright is still violated. It's a very unusual kind of circumstance that relates to music, and I think really only to music. There's not really any other medium to which this sort of concept really applies. But the goal is that if you write a piece of music, you want to get it recorded somehow. You can either get an audio recording made of it, which is a tangible, concrete representation of the creation, right, and everything that makes it. Or I could put it in notation. One or the other is fine. I don't have to do both. But yet they still both protect the same thing, which is the music. That's the artwork. It's the music, right? When you're dealing with a library, fair use is very easily applied because the library is not music. An instrument library, a virtual instrument, is not a piece of music. It is an instrument. It makes sound. In this case, in the case of Muse Sounds or a VST or Spitfire, library or East West or whatever it is that you're using, or VPO, the library is a library. It is an instrument in and of itself with an intended purpose to create music. That is its proper use. The improper use, which would violate the copyright, would be to recreate that as what it is and distribute. To copy the thing, which is a library, to copy the library, not to write music, right? That's never the case. And the way that this is covered in copyright law under fair use is in the concept of transformation. It is entirely transformative, such that the thing that is being created, that is created new and completely new. When I write a piece of music, I have made the music. The person that made the sound library doesn't make a claim on my music because they didn't create the music. They don't own the music. It's my music. And I don't share in it because I made the music. The music is mine. And as soon as I put it into tangible form, I have rights on the copy to that, not the other person, right? The use of the instrument in the creation of the music is not derivative of the instrument. The instrument can only be derived as another instrument in order to follow the track of its own right to copy or rights of copy, if that makes sense, right? And this is certainly applied in sampling. Sample is kind of a troublesome word because it's used so flippantly and it doesn't necessarily always mean the same thing. So a sample can be something that is taken. A sample is always something that is taken, obviously. I could sample a note on an instrument and then create an instrument library, a virtual instrument out of that. But I could also sample a portion of a copyrighted work, right? A new created work that has a copyright as a musical work. And I could take a sample of that musical work and then use it in music. Now you run into a problem because it's non-transformative anymore. You're not actually using a component for what it is intended, unless you've been given permission. If you've sought a licensed permission to do that, then you're fine. But you can't just lift a sample of a copyrighted work and then use it in kind in another work. That is a violation of copyright. When you're using a virtual instrument to create music, you're not violating its copyright because you're not doing something in kind to what it is. If I do, however, take a virtual instrument and I copy the tones down, even if I change the tones in some way and I use them as tones as an instrument, I'm running into a problem there. I'm violating the copyright of that instrument. If I distribute it. Now, curiously, if I do the very same thing and I make another instrument out of those instrument sounds, but then I use that instrument to make music, I'm now creating something entirely new. It is transformative. I could write music with that, right? And we do this all the time. You can take a Spitfire library, you can sample a note, a tone in your DAW, you can bounce it, you can change it in some way, or pitch modulate or whatever, and then use that as a new instrument to create music, and you have not violated the copyright on the instrument library because you have created music with it. If I do the very same thing and then I say, here, I'm giving these samples now out, if I share those samples with someone, now I violated the copyright because I violated any possibility of fair use, right? I violated the copyright as it is. I have not fairly used it. I have misused it, right? So that addresses virtual instruments, And I responded to Unfa about this with VPO, and I made this argument. And Unfa was very gracious. He came back sometime later after some back and forth. Some of it wasn't very nice to start with, but eventually we got to a cordial kind of situation where he was listening carefully, and then he talked to some people, and then he came back with another video. His response was, wait a minute, I don't actually know what to make of it. And I think that's a better place to be, right? Rather than saying, this is wrong, this is bad, when you can't prove that it is. I go a little further, right? I'm very comfortable saying that virtual instruments are you're not violating copyright when you use a virtual instrument to make music, even if that language doesn't exist. I don't have to be a lawyer to be confident about that. One question we had when we were discussing this before was he couldn't find any attorneys or lawyers or authorities at Creative Commons or whatever to verify what I was saying. And my response to that was, of course you can't find anybody to verify, because they're not arbiters of the law. They're not a judicial court. They can't make a judgment on a case. What we're discussing is actually a case. Someone would have to make a claim, it would have to go to court, it would have to be adjudicated, and then that judge would then say whether or not something is in violation. Until you get to a place where you have a claim in a case, you just have discussions. So what you can't find also is, not only can you not find some lawyer to say that what I'm saying is right, you can't find a lawyer to say what I'm saying is wrong. And if it is wrong, you should be able to find a lawyer that says it's wrong. They would give you that advice. But you can't, because it's not. It's not wrong. Anybody can read the law. The law is written for you to read. It's not written for a lawyer to read and then tell you some secret meaning. The meaning is supposed to be clear, and that's what it is. So, fear not when using these things. Now, to just kind of drive this home, again, if you have a synthesizer at home, if you have a Yamaha, I have a Yamaha Clavinova upstairs, that we use for our piano, and it's got sampled sounds on it. It's got sound samples on it. I can play that and record music with it. I don't have a license. I don't know where there's an end user license. I'm sure there's probably one written somewhere, but I can certainly do that. You've listened to music for decades and decades in the recording artist era of pop music, using electronic instruments up the wazoo, and no one's violating copyright by doing that. But it's identically the same thing. It's no different using a Korg synthesizer than it is using Muse Sounds or Spitfire or East West or VPO or Vercillion or whatever. It's all the same. Okay. Now let's get to the GPL issue. I think this is clear enough already for what it is. Now, there's a lot of debate about what this little fragment of code means and what this little fragment. I think the absolute end of this argument is that all of the code that relates to Musescore is open source. The interface at which the sounds meet up with Musescore is open source, and anybody can create a library that will interface in that way. Good luck making one as good as this. I mean, it'd be nice if someone would try, and people will, by the way. In fact, it works this way. I know it works this way because I believe the play from notation engine is what plays back the Fluid GM sound font that's still set of sounds that's still part of the program and is part of the open source playback, right? So you can download Musescore 4 and not use Muse Sounds on it. You can, and it sounds like the old program because it's using the same sounds. So you don't have to have Musescore 4 and this. This is a separate product that they have, and it makes sense. It makes sense. Why? I don't have a problem with proprietary stuff. If I had a problem with proprietary stuff, I wouldn't use my Yamaha and play on it, right? If you have a problem with proprietary sound samples, you need to get rid of all of your synthesizers. If you have any, you need to get rid of them. Don't use any Spitfire stuff, because it's proprietary, and it is on the exact same legality as this, right? You don't have to have Muse Sounds to use Musescore 4. Musescore 4 is its own thing. Now, let's talk about the program a little bit. I feel that Musescore 4 is very much a regression in terms of capability from Musescore 3, because I'm a Linux user. I was using MIDI output, live MIDI output in jack transport, and those aspects of the program have been revoked. They've been removed. Now, will there be opportunity for community development? Of course there will, because it's open source. So I would hope some of those things come back. Right now, it looks like a lot of, I don't know the case behind the scenes, but it looks like a lot of developers have sort of been burned by this, and there's not a lot of interest from what I can see in getting some of these functions working again on Musescore 4. And of course, they haven't really opened it up to that. They're trying to get a stable release right now. And I find that a crying shame, because there's a lot of capability in using MIDI transport, particularly for film scoring, which is something I have an interest in, and for syncing with, of course, rewiring with other applications, which, Linux musicians love to do. And Mac and Windows people like to do too, but they use their proprietary applications to do it, like Rewire, is how they would sync Logic with other kinds of software to make things mesh and work together in synchronized transport. But anyway, that's it. I don't find this as gray. I don't think it's questionable. I don't think there's really anything sketchy about this whatsoever. Not at all. Not at all. I have no problem with this, and I can't find a problem. I just can't. I can't look through the license. I can't look at the way things are outlined. I can't look at the way things have been historically in this arena of VSTs, virtual instruments, and applications. I mean, there's no difference between using, and some people, if you're on Windows, I believe you can, there's no difference between using Musescore 4 and running Spitfire, BBC Orchestra on it, or using Muse Sounds. There's no difference in terms of the legality of it. The playback engine is here. The instrument is here. The instrument connects here, and they all connect in the same place, and they function in the same way. Now, I think what you're going to find here, and this is where I think people get really suspicious and they think of conspiracies about it, is that obviously the Muse Sounds are going to be best. But they're going to be best because the people that developed the play engine, the people that made the sample library, are the people that made the play engine. They're making the library to work specifically with that play engine, right? This has always been this way. It's no different than having sample libraries that only work with Contact. Even though the people making the library might not have been part of Native Instruments company, right? They only work with that. It's really the same idea. The Muse Sounds will only work with this program, and I think actually one other program which is proprietary that Muse Group has. I think that Muse Sounds works. So there's another application that they have that is also employs Muse Sounds and will employ Muse Sounds. So anyway, that's my discussion on this. Virtual instruments used for music. There's this discussion about commercial use and whatever. That can only apply to the copyright itself. So when they say cannot be used for commercial purposes, what it means is you can't take the library and it can't be used in commercial libraries. It's not about making music commercially. Because the music is a transformative and appropriate use. The music is the intended use of the instrument. Instruments used to make music. But the instrument doesn't make the music. The composer makes the music. And that's where the copyright lies, is in the creation of something new and having that recorded to a medium. So, yeah, that's it. And again, a musical recording is not the same as a sound recording, a copy of sound recording. There's some people that really get worried that when I play my music and I use this tone, Well, that tone is a copy of the tone that's in the library, and the individual tone has the copyright. That is not the same thing, because this is contextually different. This tone is not a tone. This tone is a component of music. That's the part that makes it, provided that you always download your own in a manner that renders the sound file substantially dissimilar to the original sound of the sound file in each case. Using it for music does that. I could do a scale sheet, which literally plays bum, 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 right? And I could record that for students or something, and I still haven't violated this. I just have to say, it's not like you have to try hard to make a sound library dissimilar from a sound library. Like, that's really easy to do. As soon as you write a melody, it is entirely dissimilar to the library, because the melody is a wholly new creative construct. And when you put that on recording, when you record that to Medium, the copyright then belongs to that, right? As the artwork. So it's like simple. You get wholly substantially dissimilar the moment you create a fragment of music with the library, in all cases of libraries. That's and I mean, find a court case where that's been demonstrated incorrectly. And if you find this muddy and you're worried about it, again, I say to you, you really can't use any libraries. You have to make your own. You will have to make your own. Or unless you're in the open source community, you can only use one where someone explicitly says that, they've released this to you or to everybody or whatever, for all of these uses. And I argue again, when someone makes a license like that, they're actually creating legality that doesn't exist, because copyright doesn't cover those concepts. Right? The copyright only copies the one concept. I have written down something, I have a right to make copies of it. That is the concept, period. That's all it is. So anyway, hopefully this clears up a little bit of it. Musescore 4 is here completely. All of the code, everything about it. The library is here. This is proprietary and has a license, and the license looks just like every other proprietary license for every other library. It's the same concept, same language, same implications under copyright, right? This has the same interface with this as anything else that can be written, whether it exists yet or not, can be written to interface with this, which is open. And the use of this in here does not violate the GPL in the same way that using a sound font or an SFZ collection like we could in Musescore 3 with the engine that they had there, Zorbis or whatever it was, that didn't violate the GPL. It's the same exact thing. Nothing has changed. It's just the program has regressed a lot. That's what's changed, is that the capability that a lot of us Linux people loved to have before is gone now, at least temporarily. I don't know. It's going to be a long, slow walk, I think, until we see some of that stuff come back again. Now, where am I at on this? Let me just be clear. If I can get the absolute best library, instrument library, orchestral instrument library that has ever been made for free, I'm taking it, man. I'm taking it. If someone would offer me East West Hollywood Orchestra for free, I'd take it. This is better than that. It's smaller and better than that because of its design, because of the engine that's in Musescore 4, which is the engine that's in Musescore 4 is open source. It's the same engine that's using the other sounds. It's not just applied. Play from notation is not just applied to Muse Sounds. Play from notation is applied to everything that gets connected to Musescore 4. and that will grow over time. That's the plan. VSTs, hopefully LV2s in the future, if some community development can happen for Linux. You'll be able to just throw a copy of SFIZ in there and use VPO on it. Now, will it read well and will it interface well? I don't know. Probably not. There'll probably be a lot of problems there because a VPO in SFIZ wasn't designed to go with that. But this was designed to work perfectly with it, even though it is a connected entity as a library like any other library. Okay. I don't think this is muddy. I don't think it's questionable. I think it is absolutely clear. I think it is black and white. I have no problems with this. I don't think anybody else should have any problems with it. I think people are just offended. They find themselves a little offended because of what Musescore has been for so long, and they just don't like proprietary entities taking part in this. But at the same time, I say, look, you're already using proprietary stuff. You're just not really necessarily recognizing it, right? The moment, like I said, the moment you play something and record it on any synthesizer that you own, hardware synthesizer, you're doing the same thing. It is the same thing. It's not unlike it. It is the same thing. So anyway, that's a bit of a rant. 35 minutes or so. It's kind of long, but whatever. Hopefully this makes sense. Hey, if you disagree, go ahead and put something in the comments and we'll have a discussion about it. So anyway, good luck with that. Happy mixing.